All right, we are back. We're prepared to start the sentencing in the matter of People versus Xavier Edgington. File number is 252499FD. Mr. Edgington is here with his lawyer, Mr. Victor Bland. He was charged with operating while intoxicated. It was charged as a third. Oops. People versus Xavier Edgington, file number 252439FD. Mr. Edgington is here with his lawyer, Mr. Victor Bland. He was charged with operating while intoxicated, third offense, and I don't think it was correctly a third. I think it was a second offense, and the defendant pled to that charge. Also present is Abby Stoll from the prosecutor's office and Priscilla Walton from the probation department. We had a brief meeting off the record here a minute ago. Mr. Bland wanted to make sure we had all our information correctly. And now it's time for the sentence. Mr. Bland, what would you like me to know?
Well, Your Honor, some of the things that we've discussed, but obviously the first point was I was charged as a third. I think it should have been charged as a second. I pled to a second, technically proper, but certainly if we were to use the old grid scoring, that makes a difference in terms of the maximum sentence. And I think that was noted in the pre-sentence report. I think to make a long story short, I would like to follow the pre-sentence recommendation. And I realize, Judge, it's a recommendation and it's ultimately up to you. I think it was well written. I think it was sensitive. I think it was intuitive. And I think it covered all the points. Why does that recommendation make sense? Well, to me, the number one reason is he tells me he's been 5 months sober. He tells me that he has been doing breathalyzers 6 times a day. Now, there's an issue with this Courtroom I don't fully understand. I think the court and he are going to have an understanding on that. I will say from my point of view, no, he shouldn't be doing Courtroom either. His child just got released from the hospital today. It had RSV. It's a child that he and Ashley have. I think the child has turned the corner, but obviously that is a concern for him. He tells me I don't know whether he's actually in classes or signed up at Glen Oaks, but there's some association with Glen Oaks. Because of the PTO that's existing between he and Ashley's son, not he and Ashley, he has signed a lease with a separate residence. And, you know, some of these things are factors for why he would ask if the court were to incarcerate him, which again, we don't believe is necessary under the recommendation. He'd be given some time to work some of these things too. Through. He tells me also that he has gone and I think talked to the work release people. I'm not sure where that was. He thinks he's on the way to being set up with that. Tells me he works at, I think it's Ash Investments, which despite its name, he tells me is a construction company. And I don't know if he's actually went to work there or not. I know there's a concern about the LaGrange warrant. I know the recommendation gave him time to take care of that. That's what I would certainly ask the court to do. I understand that to be a misdemeanor failure to appear in an OWI. I think it's a first offense OWI in Indiana. And I think they have kind of like a work release weekend, sort of, where I think he goes in on a Friday and he's out on Sunday. And
At where? Where?
In LaGrange.
Okay.
I'm sorry if I said it.
I misunderstood.
In LaGrange, and he did not go to that, not because he didn't want to go back to LaGrange, but he tells me he was arrested on a warrant, turned himself in on a warrant for St. Joe County for domestic violence that was eventually dropped. So I don't want to, you know, it's what I call a technical abscond, but he should have turned around and made it right with them. But he didn't. And I think the important point I want to get through is that it wasn't sort of willful, you know, I'm just not going to go back and take care of it. However, he's had some time to do that. So to me, the most, one of the things that you want to do with the sentence is you want to make sure you get somebody on the path of reform, on the path of taking care of their issues. And I realize that there comes an issue, and I'm not trying to talk around that. Other than to say, I'm pretty impressed with 6 breathalyzers a day. I don't know how long that's been going on. I'm pretty impressed with 5 months sober. And I understand also he's on Suboxone. So my plea to the court would be that we follow the rec. He's told me in the past that he has been incarcerated here in St. Joe County. And I know I represent him on at least one of those. And LaGrange didn't come get him. It may be because of the fact they look at this as just a first offense OWI, but that's their reasoning. I understand. So in any event, Judge, long and short of it is, I think there's reasons to back up the recommendation. And I would ask that you follow it. Thank you.
All right, I've got a lot of questions here, and I'm going to start with some of those. Mr. Edgington, you have, since this first came back, you've had this open warrant from LaGrange County. My fear was LaGrange was going to give you a year in jail, which is why I think you were afraid to go down there. But you've known for a year or two that there's an open warrant for you in LaGrange. You also had a charge pending in Elkhart County. What happened to the Elkhart County charge?
From my understanding is that is 13 years old. When I was arrested for the OWI, I had asked them about it, and they said that it was that I didn't have. I asked the police officers, and they said that I didn't have a warrant. While I was serving time in prison, I had written them and asked if I could do a plea by mail. And they responded that upon my release, come see them in 30 days. My parole officer denied me access to go down there to do so on the basis that it was a misdemeanor. But later I was arrested for the OWI, and the officers had told me that there was no warrant.
Your felony PSI indicates you have a pending charge of no license handgun in Elkhart County, Indiana. And it says you have charges pending in Elkhart and LaGrange County. The LaGrange County is a drinking driving charge that you never appeared for your sentence. Those are 2 large factors why you weren't placed in sobriety court. You have open warrants for you from another jurisdiction. And I don't take everything you tell me at face value. All right, let's talk about something else. You told me and you told Priscilla that you worked at Basin Materials in Sturgis. Did you ever actually work there?
I did not end up taking the job. The day I was supposed to start, I was offered the job at Esch Investments. So it would pay significantly more. So I had taken that job instead.
I don't believe you. You told me you were working on 2 different dates. Like weeks and weeks ago, you told me you're working at Basin Materials. And then you told Priscilla that. So tell me about Esch Investments.
It's his name's Matt Esch. I can give you his information. He can the probation department or Twin County just spoke with him, and I was accepted to work release.
Well, how'd you get to Twin County? You went to Twin County on your own to set up your own work release?
Yes, sir. That's how I've done it in the past.
See, Basin was a lie. You told me on 2 different occasions you were working there, and you were offered it. You weren't working. And when is the last time you actually worked?
Thursday.
Which was where?
At Esch Investments.
All right, I was told you were going to start today.
No, I'm supposed to go back to work today.
When did you start there?
I have been working there for 2 weeks now. I was supposed to start the job at Basin, but like I said, I was offered this other job and I had taken that. I have messages, I have my boss's number, to back that up.
All right, so there's the issue regarding your employment. There's the issue regarding the Elkhart County warrant. There's the issue regarding the LaGrange County warrant. Let's talk about Glen Oaks. You claim to be enrolled as a student at Glen Oaks
Yes, sir.
Community College. I'm not sure I believe that
I have
either.
my ID in my wallet right
Well,
here.
an ID is one thing, and it's one thing to enroll. It's another thing to actually go to class. You've been telling me that you're working at Basin, then you tell me you're doing something else. When's that last time you actually went to Glen Oaks to take a class?
I do online. My professor is Stephen Rhino. That's my English class. I just had an assignment due last night, but I did not have the time to do it, so that assignment will be late.
So you're taking one class?
Just currently, I was enrolled in 2 classes, but I realized that algebra is a bit harder than what I remembered it being from high school, so I dropped that class in hopes to get.
So you have one online class at Glen Oaks, which you're behind in, which is a lot different than actually being enrolled as a student. Abigail, what's your thought here?
Your Honor, in my opinion, the defendant is a lost cause. He's had prior probations revoked. He has as the court's aware, he has the current warrant out of Indiana, and his prior OWI conviction is only 2.5 years old. In the instant case, his BAC was over twice the legal limit, and he had a utility pool. So, in my opinion, I think the only appropriate solution or punishment is upfront jail time.
In his pre-sentence report in the circuit court case, the pre-sentence writer states under recommendation, and this is a couple of convictions ago, Xavier Edgington is before the court on his second felony conviction. He has 15 misdemeanor convictions. The defendant has been placed on probation 7 times, with 6 ending in revocation. He's failed to begin his 7th probation term, as he neglected to turn himself in to the LaGrange County Jail as instructed, and his probation was scheduled to begin upon completion of his jail sentence. Such lack of compliance has resulted in the defendant being charged with a misdemeanor, failure to appear. Defendant having been released from lawful detention, the misdemeanor failure to appear. He also has a pending misdemeanor of Elkhart County, which he was also ordered to report to the court within 30 days of his release from the Michigan Department of Corrections. He has failed to do so. He has also received jail sanctions and 1 prison commitment in it, commitment to the past. So at that time, you did have a LaGrange County case and an Elkhart County case, and I don't believe your explanation of either one of those. You have been taking a breath test every day, but you're also using kratom, hillbilly heroin, and it's expensive, and you're taking it every day. And now you're on Suboxone. Who put you on the Suboxone?
Pivotal.
To help with withdrawal from the kratom?
Yes, sir. I've been off of that for almost 2 months now.
All right, Priscilla, I'll give you the last word.
Your Honor, I believe that you yourself and Ms. Stoll has said what I needed to say, but my recommendation was based on that, yes, Mr. Edgington has a lengthy criminal history and a history of having probation violations revoked. I was on the fence of this as to give Mr. Edgington another chance of probation, but I'm willing to, if the courts decide to place him on probation, I would like him, like I stated in my recommendation, for him to take care of his warrants that are active out in LaGrange and or Elkhart County. The only issue that I had was, I am aware that Mr. Edgington has the issue with Kratom. He states that hasn't used it for 2 months, but if he were to relapse, I don't, it could be an expensive test if I were to send him over to day reporting center. That's my only issue with placing him on probation. But as to why I also gave him, 20 days deferred. So if he is unsuccessful from this probation, he has that chunk of jail over his head.
Judge, I think he wants to address the keratin.
Go ahead, Mr.
That is something that I struggled with. I did not understand exactly what it was at the time. But like I stated, I have been off of it for some time. And I've been working with Pivotal diligently to maintain my sobriety.
Is that sobriety from all substances?
All substances.
Do they test you? I'm sorry, Judge.
I have not been tested for anything, no.
Well, you're doing the PBTs, but that's through the corrections department.
Absolutely, yes, sir.
All right, nobody's testing you for the keratin.
No, sir.
But just so we're clear, you believe you've been off of it for 2 months?
For some time now, yes.
And what caused that? What was the
It's
light bulb going
expensive.
off?
With me getting sober from alcohol, that was my number one thing. I understand my record is lengthy and it's terrible. And I don't contest that. I have turned it around. I'm training for a crew lead position, which pays upwards of $40.
Training for what kind of position?
A crew lead. It's Ash Investments is a construction company. It's on the corner of Featherstone and Schimmel. I was just speaking with my boss before I came into court to let him know what's going on. It's somebody that posted a job on Facebook. I have W-2 or I have check stubs to prove my work. It is a taxed job. It's not a 1099 or anything like that. Having this baby, I have 3 other children and I don't have rights to any of them, but with the baby I do, or I'm not on the birth certificate yet, but I'm going to be. But the baby has changed my life.
What's the due date?
For the baby?
Yes.
January 3rd, 2026.
Okay.
Her name is Sophia Marie Edgington.
Yes.
So she's already born.
Okay, she is born.
Yes, we were just
I guess she
released.
wouldn't have a name of Sophia if she wasn't already born, so.
We were just released from the hospital this morning. We've been in the hospital since Thursday night. We went to Sturgis and then we're transferred to Bronson. And I have release papers that I had left the hospital and came to court. My fiance's father came and picked the baby up, so we were able to come here. And then after court, I was supposed to go back to work. I understand. On paper, I look terrible.
Well, the one thing you left off, when you got arrested, you threw Ashley under the bus. The first thing you said to the cops was, Ashley was driving, I was not. Like, how bad is that? You're a 178. You crashed into a pole. You tried to blame it on your girlfriend. Yeesh. People saw it and saw you driving. You should be ashamed of that.
And I am.
All right. I'm gonna allow work release.
I will say the arresting officer in the case is the one that came, tracked me down to tell me about that I was being mischarged. That is Officer Cleaver of the Sturgis PD. And I've had a few contacts with him since, just in checking on me and telling me that he's proud of my sobriety and that I'm
Now,
turning
somebody who was in your corner was Betsy. She always was supportive of you. I should pass that along. But I don't know what point you quit. So also you were under 7-0 or kratom when you had this wreck. And then you were going through withdrawal. You were spending $200, $500 a week on kratom. I'm not gonna do a probation because I'm not gonna set you up to fail, and I don't believe everything you say. You need to go take care of your Indiana warrants. I don't believe that you're much of a Glen Oak student. You've got one part-time class that I don't even know if you have a 1 credit hour accomplished. I'm gonna order 32 days, credit 1, leaving 31 days to serve, which may be served as work release. All the money I take from you is money away from your family. So the fine is 0. There's a $75 crime victims' rights fee, a $50 state minimum fee, $150 attorney fee.
Your Honor, I'd
Yes.
like to amend that Sturgis PD is requesting restitution for $255.
All right, there is no attorney fee. Mr. Bland is retained. And I will say, your employer has been a very vigorous advocate on your behalf. But at some point, you gotta own your own stuff. You're 2 times drunk, you're using kratom, you crash into a tree, you tell the cops it was your girlfriend. You have an open warrant from Indiana and LaGrange County, an open warrant from Elkhart County, PPO against you. Nobody inflicted this on you. You did it all to yourself. So I'm going to let you do this. We'll confirm that he actually has a job at Ash Investments.
Judge, he's asking that he can report on Friday.
Yeah, I'm going to 2-month non-reporting probation. Priscilla will set this up. That way, if you don't go to report for your sentence like you did for Elkhart and LaGrange, I'm going to give you 365 days. So you set up work release on your own without even our knowledge, but I'm not going to oppose it. Let's see how much you owe me. 125. No probation oversight fee, 255. 255. $380. That's due by June 30th. There's also a cost to being at probation center.
I don't mean to quibble, but originally I heard the court saying that you weren't placing him on probation.
I'm not. I have a 2-month non-reporting probation. And so if he doesn't show up for his sentence, it'll be a probation violation. And I will have a probation violation hearing and impose the maximum sentence. So you need to show up. Two felonies and 16 misdemeanors, plus a couple other things that are uncharged. I hope you have turned the corner. I want you to meet with Priscilla and she'll coordinate what's going on with the Twin County Probation Center. All right, you're good to go.
Thank you, Judge.
Give that to Priscilla. All right, it's 12:18. Could be worse. We'll take a recess and be back at 1:15.
Today in People versus Xavier Edgington, a routine OWI sentencing quickly turned into a powerful courtroom confrontation. The defendant, charged with operating while intoxicated, allegedly a second or third offense, faced heavy scrutiny over his credibility, open warrants in multiple counties, and inconsistent statements about employment and education. Despite claims of sobriety, work progress, and a newborn child, the judge questioned nearly every detail, highlighting past probation failures, a history of misdemeanors and felonies, and a prior crash where he attempted to shift blame. The defense pushed for probation, citing recovery efforts, work release plans, and family responsibilities. But the prosecution argued he remained a risk, pointing to repeated violations and substance concerns. In the end, the court rejected full probation. Instead, the judge imposed 31 days to serve with work release, plus strict conditions to address outstanding warrants and compliance issues. A final warning was clear. Failure to follow the court's orders could lead to a full 365-day maximum sentence. Justice, in this case, came with a second chance, but under strict supervision.